Please. Mr. Kendrick Cuba. Thank you. Okay, we are on the record in State of Texas versus Kendrick Cuba, cause number CR 23-28815 and CR 24-28891. And sir, you are Mr. Kendrick Cuba, correct?
I am. Before we get started, I'd like to point something out. I was picked up on the
Okay, Mr. Cuba, I need to go ahead and get you sworn in, and then we're going to just one moment. And then we're going to move forward with the pretrial. So just bear with us, but we're going to have you raise your hand to be sworn in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. You may put your hand down. All right. For the attorneys, this is our pretrial. We have several motions that have been filed. We're going to step through those. But first, is the state ready to move forward on the pretrial?
Yes, Your Honor.
All right, Ms. Wozniak.
Before we go,
Mr.
I tried to file her. I don't want her on me as a trial attorney or nothing. If we're going to trial, I do not want her as my attorney because I have.
Mr. Cuba, I'm going to go ahead. Mr. Cuba, we've already addressed this, and I've already denied your request. Okay, Mr. Cuba, I've muted you. We're going to address this momentarily. Ms. Wozniak, do you need a breakout session with your client at all?
No, Your Honor.
Okay. Just one moment. Let's go ahead and address the pretrial. Please listen to the motions and the things that we're addressing. Okay. From the state's perspective, I see motions filed on the 7th. Were there other motions that the state had filed earlier?
No, Your Honor, not that I do not believe so.
Okay. Now I'm going back and looking at some of the earlier filings. And I want to point out that on July 29th, Mr. Cuba filed his own motion to dismiss. Two things. One, there's no hybrid representation. And number two, the information that he has in this motion, Mr. Hazelton, I'm just going to give you a chance to look at that. Ms. Wozniak, was there anything here that you had wanted to urge that you believed legally was an option?
Not at this time, Your Honor.
All right. So this was making requests about a speedy trial. The court has set the matter for trial. We are addressing the pretrial now. I want to move forward. After that setting, we did address having the trial set, having the cases set for trial. And the state had their offers on the record, and the defendant declined those, which is his right. Then we did see another pro se filing by Mr. Cuba as it related to cause number CR 23-28815. And this is where Mr. Cuba is of the opinion that this is a Class A misdemeanor, family violence assault. And the state has indicted as a felony. So this is not a Class A misdemeanor.
All right, guys. Today we're going to watch a courtroom situation that escalates faster than most defendants expect. From the opening seconds, the tone is set with sarcasm, frustration, and a blunt breakdown of why this case even exists. The defendant is introduced, the charges are explained, and the courtroom officially comes to order. This clip matters because it frames everything that follows. Who this defendant is, why he's angry, and why the court is already on edge before a single legal argument even begins.
And it's also the defendant's pro se or attempted effort to file a motion to dismiss. This is the same information I have received from Mr. Cuba multiple times. He is of the opinion it's a Class A misdemeanor, and the state has indicted as a felony. So I want Mr. Cuba to know we're well aware of his position on this, and the state is well aware of it, and importantly, his attorney is well aware of it. All right, now we go forward, and we're looking at September 9th, and we have either a different or the same motion. Okay, yeah, Mr. Cuba, if you'll listen to the information, you'll find it helpful to you. And it doesn't, you're showing us a document that looks like the bond, where the original bond was set on a Class A misdemeanor. And then when it gets filed with the DA's office, they have the ability to look at prior convictions, if there are any, and then the state can take action to enhance it. And I believe we went over this multiple times, but we're going to go over it one more time so you have the benefit on the record of understanding. Let's look at that indictment so you can see what the state has in fact addressed, because this is the indictment the state's moving forward on. And so when you look at this, you're going to see, we're going to make it a little larger because there's a lot of words on here. If you'll notice, it's entitled Assault of a Family or Household Member, but with previous conviction. All right, so that tells us that it was a Class A misdemeanor, a pinning her to the ground and a striking of her, but previously the defendant had been convicted of family violence on April 26, 2018 in the 336 District Court in cause number CR 17-26281. So when you pinch somebody, slap somebody, hurt somebody, and it would otherwise have been a Class A misdemeanor, but you have a prior conviction for family violence assault, then that becomes a higher level offense. In fact, it becomes a felony 3, 2 to 20. And then we're looking at the enhancement provisions, and Mr. Cuba has also the 3 enhancements, and effectively they're sequential. So this makes the felony 3 that he believes is a Class A assault actually punishable by a minimum of 25 years or a maximum of 99 years or life because of the number of prior convictions. All right, we went over that previously, but we are at the pretrial, and I want to make sure that that's been refreshed for the benefit of Mr. Cuba. We do have a bond violation at some point by him in 2023. A failure to appear November 9th, 2023 is reflected in this offense or this cause number. And now we're moving forward. We've covered those motions to dismiss. A lot of filings by the defendant on his own behalf. We do have a competency that was done. He was deemed to be competent by the doctor and the court so found, and that was in June of this year, or July was actually the date that the order was. And Mr. Hazelton, you can correct me, but the first filing I'm seeing is the state's motion of intent to introduce audiovisual evidence.
Yes, Your Honor. I believe that would be the first of the state's filing.
Okay. So let's go over this. What exactly is it that you have in the way of video evidence that that you intend to offer?
Your Honor, that would be body cams dealing with the witnesses during the day of would be my intention, and I believe there would be a 911 calls would be what we were looking at. I believe me and Ms. Wozniak will be able to work this out. We haven't been able to conference on the issues of AV, but I believe we would be able to address these, and if there was any issues, if we needed, we could further press the court for, but I do not believe that would be an issue at the moment, Judge.
All right, Ms. Wozniak, your position? Is this your understanding?
Yes, Your Honor. Mr. Hazelton and I will further conference about the admissibility of those before trial. And if there are any issues, address the court, but I don't foresee any issues, Your Honor.
Okay. So let's, out of an abundance of caution, give you all a date certain. The trial setting is October 28th, and this is our top case. So Mr. Cuba's case will go to trial.
Judge, I thought our trial date was November 18th.
I'm sorry. I stand corrected. Yes, November 18. I was thinking about my next trial date. You're right. The next one here is November 18. So we've got a little more flexibility on when we could select a pretrial date on the audiovisual, just to make sure any agreements y'all have are actually, I'd like to have those memorialized before we get picking the jury.
May I propose November 6th? That'd be a Wednesday, so 9 a.m. I would believe that we would be done with the trial the prior week before, and I believe that would give us sufficient time.
Ms. Wozniak?
That works for me, Judge.
All right, that'll be a 9 a.m. setting. So, Mr. Cuba, we're going to have a 9 a.m. setting just for the audiovisual, and your attorney will have the benefit of going over this information with you. Ms. Wozniak, would it be beneficial at all to have the ability to go over that here in the holding cell on video so that Mr. Cuba had the benefit of being here and going through that, we can memorialize all that on the record?
To have him watch the video while he's at holdover, Your Honor?
Yes, because I don't know what kind of cooperation or support y'all are getting from the, access that you have to show him the discovery at the jail. This would just give you a time frame, and then we would have the benefit of getting all that finalized.
That would be, yes, Your Honor, I'll take advantage of that offering. Thank you.
Mr. Cuba, I saw that you had your hand up before. Just a second. Let's get the jail to jail to unmute Mr. Cuba momentarily. Let me double check what Mr. Cuba has here.
To a jury selection.
There will be a jury, sir, there will be a jury selection on November 18, and you'll be here for that, but we're also bringing you in on November 6th. We're going to have you reviewing all the videos on November 6th here at court, okay?
The ones you're fabricating, right? Why do you keep putting me out month after month after month after month? What you're doing is you hold me in this jailhouse because you're really a racist, and I don't like being up under you because you are Joshua Reed's mother, Joshua Reed Blackman's mother, and you are the same judge who gave me 10 years 10 years ago and recommended I do not recommend parole because I had a drug case, not an assault case, and you're putting all these charges. You steady putting me off. This is a Class A misdemeanor, and you're trying to do all these crazy enhancements from 25 to life on a Class A misdemeanor.
Okay, Mr. Cuba, first of all, I'm not that, Mr. Cuba, please listen. I've muted you. I am not that person's mother. I didn't do anything with contesting anything with parole. I don't know what you're talking about. If what you mean is the offense for which you were convicted affected your parole, that would be a different issue. And this court would have signed it. And yes, I am a judge who's previously handled your case. So, all right, we're going to then move forward. Let me memorialize on the face of the state's motion to produce that video evidence of this setting. Okay, the next filing I see, and I'm going to go ahead and just screen share this so that Mr. Cuba can see the documents that we're talking about. And this is the state's motion in limine. And Mr. Hazelton, is there any reason to not take this up at the time of trial? Or do you have some? Okay. All right. Then we have also filed the state's request for disclosure of experts 20 days prior to the beginning of trial. Ms. Wozniak, any objection to this motion?
No, Your Honor.
All right. The next motion we have filed is a defendant's motion. And this is the defendant's motion, a formal motion for discovery. Ms. Wozniak, is there anything else you wanted to address on this filing?
No, Your Honor.
All right. And Mr. Hazelton, has the state provided the discovery?
Yes, Your Honor, we have complied with 3914, and I've provided everything. If anything is to come in, I will timely provide it over to Ms. Wozniak.
Okay. And then I'm just going to encourage the parties to make sure that also on that November 6th date, it's another opportunity for Mr. Cuba to get to see the information that the parties have, the state has, and has provided to the defense for discovery. All right. And then it's my understanding, based on the face of the indictment, he's not probation eligible. And so there is no application for probation. How many day trial does the state anticipate?
2 to 3, Judge.
All right. So we're looking at maybe Wednesday to Thursday?
Yes, Your Honor, I believe we could do it by Wednesday, but to be safe, Wednesday, Thursday, Judge, yes.
All right. And Ms. Wozniak, is that consistent with your expectation?
Yes, Your Honor.
All right, just one moment. Mr. Cuba, one moment. Let's get you unmuted. If we'd have some assistance by the jail. I hope you've been following along and listening, Mr. Cuba.
Yes, can I ask for a bond reduction?
The court is not inclined to give you a bond. You had a failure to appear.
No, I'm not. I'm asking for a bond reduction. See, this is you're holding me in this jail so you can fuck over me. You're either gonna try to put me on the chain. Beat me up or molest me or poison me or do something to me.
No, sir.
So
No, sir.
I'm not asking for a PR bond. I'm asking for a bond reduction.
Okay, Mr. Cuba, I'm not setting a bond because you failed to appear to court. When you fail to appear, the court's not going to set you a bond
I
anymore.
didn't fail to. So let me ask you this, Ms. Blake. When was this actual court date? Can you tell me that?
Okay, Mr. Cuba, we have that other indictment. I'm happy to pull that up for you.
Or
But there
would
was
you
a date
please,
certain.
would you please pull that up for me, please, ma'am?
Yeah, one moment. All right, so here's the indictment. And I'm also going to go to any other information that we have. Now, what you have to remember is, now listen, Mr. Cuba, your attorney is going to, Mr. Cuba, if you're not listening, you're not understanding what information I'm trying to share. Your attorney is going to show you what information that the state has or does not have. And we're actually going to also have you here on that November 6th date, so you'll be able to go over all of it. And then you'll know the strength or the weakness of the state's case. But this is the allegation that you failed to appear on November 9th.
So where's the date? Where's the date down here for me to appear in court?
Sure, sir. Let me show you these
Where's the
dates.
card number? Why is this filed 5 months later?
Mr. Cuba, if you'll look and see some of the documents in response to your questions, you received a PR bond, and then 5 months later, the state returned the. Now look, the state returned the indictment in that assault case, and then we go on forward.
6 months later.
Okay, we go forward. Yeah, Mr. Cuba, if you're not going to listen, I'm going to have to mute you because I need to get you the information. Okay, now there was a bond that was set. And here's the bond violation report. And your attorney has this, and this is one she can give you a copy of. And you can disagree with the information, and we want you to have your position. The court's not trying to change your position. I'm only trying to show you the information. So when this case, let me go to the.
Why don't I have this document?
Sir, you're just. Bear with us. Your attorney has there's certain things she can give you and certain things she can't. And we're happy for all of those things to be, make sure we've gone over it one more time. Mr. Cuba, please. Now, when you received the PR bond from Judge Skotnick, he had various conditions, including reporting to bond supervision. So that was part of the expectation.
I don't have that document either.
All right. But now listen, the judge. The document
I have is the bond that they just gave me.
Okay, so the document you have is the bond they gave you, is what I heard you say. Now, I'm showing you the PR bond that you signed off on, and then there was a bond violation notice that went out, and the court signed that, and that was in October. Let me make it bigger so you can see it.
That's a whole different case, card number. Nah, that's a whole different case of card number what I got.
Yeah, well, sir, it's what they have. It's what they have in the system to track for someone else. For the bond. When I say someone else, I mean bond. When I say someone else, I mean bond supervision. I've muted you because I've got to get this out to you, sir, and you keep interrupting, and we want it to be on the record. Okay, so this was the information that the state had. Now, So you did not report to bond supervision is what they're showing. Okay. Well, we'll make sure you have that copy. And then you were to be here for court. Now, your attorney will go over the information about whether or not you had notice. So here was the information that was sent to you at the address. That was the notice for you to be here. And then we're showing you didn't make it. That day and you weren't here. Now, if your position is that you never received the notice, you need to make sure that you talk to your attorney. And your attorney has documents and she's going to go over with you what she has, what the state's providing. Maybe the state can prove their case, maybe they cannot. But that's something that we're going to get resolved on that date certain. In fact, that November 18th date, we're only going to go on one of the cases, I presume, because they are not out of the same set of facts. Is that correct, Mr. Hazelton?
Yes, Your Honor, I believe so at this time, yes.
Yeah, because we can't do a failure to appear if we're doing the family violence assault.
Correct, Judge.
Okay. Now, if we're doing the family violence assault, excuse me, if we're doing the failure to appear, we do bring in the other felony to prove that it was a failure to appear felony level.
Yes, Your Honor, and I would anticipate maybe bringing it in. I could bring it in the assault as 404B, as sign of guilt and failed to appear, but that would be something I would provide notice to Ms. Wozniak prior to trial.
Okay. All right. So, Mr. Cuba, these are all documents I want to make sure you're talking with Ms. Wozniak about so that you can see and understand what the state's saying. You can be a vociferous advocate for yourself. We want you to be, but I need you to understand what they have so that you're making, so that you're feeling more informed. Okay. All right. Now, for purposes of the pretrial, Ms. Wozniak, were you agreeable that a 2 to 3 day trial was what you were expecting?
Yes, Your Honor.
All right. Is there anything further from the state's perspective before we conclude our hearing today?
No, Your Honor.
And I think the state has already previously put on the record their final offer was 2.
Yes, Your Honor. We had previously mentioned that at the last hearing. Since that last hearing, me and Ms. Wozniak have tried to come to some kind of negotiations. I believe we're going to be too far off, but nothing's changed, Judge. No.
Okay, so the last and final offer was 2 years in each case.
Yes, Your Honor.
All right, and Ms. Wozniak, was that your understanding?
Yes, Judge.
All right, and so if I could have the assistance of the jail one more time, I want to make sure, well, Mr. Cuba's leaving. Wanted Mr. Cuba yeah, Mr. Cuba, go ahead and unmute. Mr. Cuba? Yeah, Mr. Cuba, you heard the state's final offer, and it's my understanding you do not want 2 years in either case. Is that correct?
What do you mean, what case? Either case or the only one case? Am I correct?
I'm not sure what you're, ask that question again, sir. I didn't understand.
If I'm not correct, there's only one case. I'll accept 2 years probation, yeah.
Saying, okay, and we'll have the record reflect he's walking out. So he understands that it's 2 years' time and he wants probation. Okay, I couldn't hear you. Yeah, sir, I can't hear you.
So,
Yeah. Sit down and speak. Sit down and speak, sir, if you want to be heard. But
Well, have with this jailhouse. I don't want to sit here. Send me to another county to where I feel safe. I feel like my life is in danger at this jail, and y'all are trying to hold me here so they can do something to me at this jail with your people under this Peckerwood patch, this ABAC, this white knight patch y'all got going on.
okay, so you understand that the state's
Hey, you gave me 10 years. You're still trying to give me some time. This is a class A misdemeanor. Time served right now, so I'll not come back to Fannin County ever again. I promise you.
yeah, Mr. Cuba, Mr. Cuba,
I promise you, Ms. Blake, if you do that for me, I'll never return to Fannin County again, ever.
Mr. Cuba,
I beg you to please give me 5 years probation. Let me exit Fannin County right now. I'll never return ever again, ever. I'll take 10 years. I'll take 10 years probation right now. I'll take 10 years probation and leave Fannin County right now.
Mr. Cuba, the court.
10 years probation right now to leave Fannin County and never return again.